very refreshing points. So thank you.
Thank you so much. It was a pleasure to hear Professor Soumya, and it has been long, many, many years since we shared the same podium from NLS days, and it was lovely. It was very informative, and thank you so much for inviting Dr. Garima, Dr. Anand. It was wonderful.
Thank you, ma'am.
Good morning, everybody. I would request Dr. Arifa Zahra ma'am to please turn on her camera. Good morning, ma'am.
Good morning. How are you?
I'm good, ma'am. Thank you so much. How are you?
Yes, I'm also good.
Just give us a minute.
All right.
Mr. Altamish Siddiqui sir to please turn on the camera.
Hi, good morning.
Hello, sir. Good morning. Good morning to the dignitaries and all the participants present. I, Shreya Khildare from Maharashtra National Law University, Mumbai, will be the comparer for this session. I welcome Dr. Arifa Zahra, Assistant Professor, Amity University, Dubai, Mr. Altamish Siddiqui, Senior Legal Consultant, Legal INZ, UAE, and Mr. Ayushman Tripathi, Research Assistant, MNLU Mumbai. I would like to introduce our dignitaries for the session. Mr. Altamish Siddiqui is a seasoned legal professional currently serving as a senior legal consultant at Legal INZ, a prominent law firm based in the UAE. With a wealth of experience in the legal arena, his expertise lies in providing comprehensive legal counsel to clients on intricate legal matters. His day-to-day responsibilities encompass advising clients on complex legal issues, reviewing legal documents, and collaborating with local Emirati lawyers and law firms for case filings. Furthermore, he is adept at drafting a wide array of civil and commercial documents, facilitating agreement reviews, and assisting with negotiation processes. Additionally, he plays a pivotal role in formulating and reviewing firm policies and procedures. Before his tenure in Dubai, he honed his legal skills at the chambers of senior advocate Geeta Luthra in Delhi, India. With over 5 years of experience in litigation, he has appeared before the Supreme Court of India and various high courts, handling diverse cases spanning criminal law, arbitration, civil disputes, and matrimonial matters. Dr. Arifa Zahra is a distinguished academician specializing in international and commercial laws, currently serving as an assistant professor at Amity Law School. Dr. Zahra brings a wealth of knowledge and expertise to her teachings and research endeavors. She holds a PhD in law from Aligarh Muslim University and a Masters of Law in Corporate and Business Laws from Gujarat National Law University, India. Dr. Zahra's scholarly pursuits encompass curriculum development, research methodologies, and teaching practices within the realm of law. Her areas of expertise
No, so I was sitting.
Hello, actually there is the net got interrupted. That's why the devices from the host side got closed, but we are reconnecting. The computer, the anchor, and the moderator is reconnecting in a second. So very apologies for Yes, we are about to join back.
Hello, hi. Am I audible?
Yes.
Hello, sir. Sorry for the issue. I believe the Wi-Fi suddenly was disconnected. So
No problem.
we'll just jump right back in the session. And I believe the introductions were over. Thank you so much, Shreya, for the introduction. Welcome, sir. Altamish, sir, it's a pleasure having you here. It's an honor having you here. Arifa, ma'am, I believe she's also here. Yes. Hello, ma'am. It's an honor having both of you here with us. Without wasting any more time, as we're already running behind, we'll start with the session. The theme of the session, that is the third session of the day 2 for the Gender Data and Technology Summit, is disruptive technologies and specifically focusing on safety in the cyberspace. Will I'd like to invite Altamish sir first for his address to the crowd, and we'll start with so what, if you don't mind, would you like to share your perspective on specifically gendered disruptive technologies in the cyberspace concerning the safety of the users?
Sure. First of all, thank you for having me here. It's an absolute honor to be here sharing dice with Dr. Zahra as well. In terms of how disruptive technologies can be, used to either give more gender equality, and how this is not currently the situation in most of the countries. I feel the reason is that a lot of times that how we see is that social biases, norms of the society that define us. We know that how a lot of societies, including India, are patriarchal. There are conservative norms going around. Those how translate into cyberspace as well. And thus, unless there are active actions undertaken by the uh, state level authorities as well as the society as a community, these gender biases can lead to direct gender violence as well, which can be much more relevant in today's cyberspace. I feel that the current landscape lacks a lot of it that we see, and there is a lot of area that we can cover. Of course, there are various examples around the world where a lot of countries are taking active steps. There are few international organizations actively working on it. There are NGOs working on it. But of course, I feel there's a lot of gap that can be covered on this specific aspect. So that's just 2 minutes of my bite on this. I'll ask Dr. Zahra to jump in on the same.
Thank you so much, sir. Dr. Zahra, please.
Yes, first thing, and which is a very prominent aspect that we have to keep in mind, is whenever we talk about artificial intelligence, or let's say machine learning or cyberspace, and hence we come across with the concept of disruptive technologies, because now they are not only assisting us, but they are also controlling us in a way. And hence, what can we do about it is obviously, as my co-panelist highlighted, there is a lot of gap that we need to cover in order to come up with the protection laws, especially for gender specific issues. And hence we have this panel discussion. Before going into the actual thread that we have, I would like to highlight various AI tools which we have in the cyberspace. So when we talk about artificial intelligence and machine learning, yes, they analyze data and our patterns, and hence they give us a potential prospective solutions to our current problems. At the same time, a prominent threat to this aspect is adversarial learnings, wherein attackers, what do? they manipulate the data because obviously they know how to hack. Yeah. So by hacking, they manipulate the data, and that's why the prospective results or the potential aspect that we are looking for, they are hindered. Similarly, we have the concept of Internet of Things, and I believe we all use it, especially governments are also promoting Internet of Things, or let's say any kind of application on our phone, which gives an alert to our family members if there is any kind of health hazard or if there is any issue in our behavioral aspect. Just like we have the concept of Tesla application in Tesla cars. So if you get the premium version of it, obviously you have more connectivity to different applications. Similarly, we have Ear BQT. So what exactly does this application do? This application gives an alert to your family members, just like in Apple, we have health application. In other softwares, in other phones, we have the concept of Ear BQT, which gives over-the-air patterns to your family members and hence sends you the alert. So yes, see, we can't be stringent if we are lawyers saying that it is harming us. It is also facilitating us to a great extent. But to what extent we should allow this to facilitate us, it is up to us. And that's why we have to come up with various regulations in order to control it in a humane manner. So that's my input.
Sure. Thank you so much, ma'am. I would also like to agree with one of the point that when we speak of disruptive technologies, there is always a balance. There is obviously a value that they bring, and the value to the problem ratio is something that we have to calculate. Is what sort of values they're adding to our day-to-day life, and that is why the discussion is there in the first place. And disruptive in general has a very initial perceived perspective that it is not going to be. It's not a positive word when you hear of the word disruptive, but disruptive can be perceived in many other ways as well. So thank you so much, ma'am, for sharing. We'll start with some basic questions of when we talk about the regulatory landscape in terms of AI. That's a very big question. A lot of jurisprudential questions in terms of AI is also concerned. Let's say stuff for starters. I think anybody with a basic legal background can come up with a question like this. For example, liability. For if a self-driving car is there and if any mistake is caused by artificial intelligence, who will be liable in that scenario? So we'll start with Altamash sir. Altamash sir, would you like to share what are your thoughts on what regulatory challenges might be there in terms of pinpointing liability in AI?
I think that's a very valid point. The main issue which actually arose as soon as the cyberspace became the common norm was, of course, that there were no jurisdictional boundaries. A lot of time there were transnational attacks, cyber attacks, where the person may be sitting in one country, the act used, for example, a vehicle in some cases, a computer in second cases could be in a second country. The person who's actually affected may be a citizen of a third country. So those jurisdictional, geographical, boundaries were dissolved when cyberspace eventually, grew up with the development of this internet that we currently have. And hence, this whole concept of liability becomes all the more difficult to pinpoint, and to what extent should we keep the liability of, entity from one country to the second one to the third one. And then, of course, a lot of companies who may be part of it, and we see it not just in terms of automobiles. We see this in apps such as Facebook, Twitter. We keep hearing about how a lot of these entities are under the pressure of a certain government in a certain country, may not allow some actions to be taken, or may allow some sort of activities which may hinder somebody's freedom of speech as well. And then how do you hold them liable? So it's a difficult question in the sense, because a lot of this is under development, and a lot of it, if I may want to give a very recent example, there is it- it's difficult to believe that, but as of today, there is not a single UN convention which can deal with it. For the past 3 years, a lot of countries are trying to have this convention called for Convention on Cyber Crimes, which is a UN convention being tabled in General Assembly. Hopefully will be ratified in 2024. And one of the important aspects that it deals is how do you share data of one citizen of a country with the other one, and what protocols to be followed, what
Right.
things to be covered in order to ensure that the rights of a certain person of a country are not violated by others. India had very recently, about 6 months ago, had raised objections that they want the data to be, shared only under their own domestic law, which is again under consideration. So hopefully we'll see a lot of development on that. But as of today, I think a lot of countries, specifically India, UAE, etc., are dealing them with their own national laws, and a lot of international conventions are usually used as a sort of guiding factor to develop their own and amend their own laws. And this is where I think we still have a lot to see in terms of legal developments.
Uh, Thank you so much, sir. Just again, one more thing that I also agree with is that in any sort of regulatory or legislative development in any new field, any developing field is coming from a global perspective. Even right now, when we are studying AI or data protection regulation, we are still going back to the GDPR and the AI Act and other regulations. Let's say some new legislation came in Brazil, some new legislation came in Japan. So these are the only 4 or 5 legislation that we are going back to. Now, moving ahead with that in that direction, I'll also like to take Zahara ma'am's opinion on this liability in AI thing, AI situation, and not only the car crash example, any bias that is coming out of AI, and any example for that matter. So, Zahara ma'am, please.
Yes, when we talk about autonomous vehicles, obviously they are a certain boon to us because we don't have to rely on manual cars or cars that needed a lot of human force and human efforts. Now we have automatic and smart cars. Now comes into picture the clause of liability, especially in insurance cases. Yeah, because it is AI, it was not our fault that the crash happened or the accident happened. Obviously, to whom we are going to say that yes, you have to pay from your pocket. Now comes into picture the principle of vicarious liability. So law assumes that if you are the owner, you have to pay for whatever harm is caused because of your object or your car, because this is a car accident. In that case, Indian law is lacking a lot because Motor Vehicle Insurance Act, it talks about only the cadres of insurances which are there for the people who are involved in the actual car crash or the car accident or any kind of harm caused to a third party. So there is a concept of comprehensive insurance and obviously third party insurance. So if we have comprehensive insurance, both parties will get the insurances even in case of smart cars because you are the owner. So there is no direct law that is covering this aspect, but because there is an implied jurisprudence on it as vicarious liability principle, so yes, that is covered over there. Now, when we talk about global aspect, yes, we are having conversations about having a uniform law for all the countries in order to control the cyber crimes at global level. We do have Budapest Convention. We do have organizations like Interpol, Europol, but obviously, as it is an international law, as it is something which is not binding in nature on domestic countries, so obviously here comes into picture the lacunae. So we have to give ratification to these treaties in a very enforceable manner. We don't have to take such laws for granted. If you want to avail only, then you can avail. No, if there is a car crash, or let's say if there is a liability that comes because of such cyber crimes, then it should be binding in nature. It should not be a mere choice to you to either you want to go ahead with it or not. On this point, I would like to highlight one thing. In the year 2016, India terminated all its bilateral investment treaties. The reason being, India wanted to come up with a new BIT model, bilateral investment treaty model. Every country has its own bilateral investment treaty model because obviously it is in between two countries. So if we are terminating all the BITs, now the expropriation clause which says that if there is any harm to the property of the investor, the remedy is arbitration to you. You cannot avail the national remedies which are there. Now here what do we see? We see that investor cannot take the umbrella of international law because it is not that binding in nature. At the same time, you have withdrawn all your BIT protection which was earlier given to the investors, especially foreign investors. So obviously what do? They run to their home countries in order for the protection. And again, there is a lacuna, so which we need to address. So collaboration in all these organizations, especially India should also have an organization. And after 2023, obviously the bill was passed, data protection bill, in which there is a data protection board that we have now. And it's not just that it happened in 2023. Even after passing of Information Technology Act 2000 in 2005 and the amendments afterwards, we came up with the concept of a cyber unit in every police station. But that is again for the domestic protection. And that is not available to the foreign investor. When we talk about cyber crimes, especially for gender issues, specific gender issues, yes, you have online complaint method as well. That means you can go online and you can register your complaint if you have any cyber crime, especially harassing, cyberbullying, or revenge porn. Laws are also there. Sexting laws should also be there, which are not there prominent in nature. It is there implied. And one thing that as a lawyer, I feel really disheartened about, that we don't talk about these issues openly. We somehow tend to think that this is our identity as Indian citizen, that we should not be talking about these things. These things should be discussed inside your house or amongst your own friends and family. Don't discuss it on such public platforms. That should not be the case, because this is a very prominent threat that we see these days. One thing that I would want to highlight, other than these gender threats that we are discussing, there is an ethical threat as well. Now, what is that? Noam Chomsky in the year 2023 read an article in New York Times. He specifically mentioned the fact that the concern is that there is a constant fear, even if AI, different variations are most fashionable in nature, they are most fascinating in nature, just like iPhone, just like different applications which we see just to edit your photo and then you can become a superstar or a celebrity-like person. But it has the tendency to debate your ethics and to deter the technology by inculcating various forms of language and knowledge. So how are we going to cope up with that? Nobody also talks about it. We are only excited to use it and then to show it off to our friends. So yes, that's my input on this.
Thank you so much, ma'am. A lot of concepts, a lot of areas were discussed by you also. You came up with, you started with the car crash and the legal liability, you discussed. And so ultimately, you also mentioned the transnational issues you started with, and then the problem of data localization is also something that you discussed. So we'll step ahead one by one, and we'll start with, we'll go back to Altamish sir only. And so, as you said, the transnational issues are there when you're dealing with multiple nations. There will certainly be a regulatory dispute, and even with well-established laws, we see that. So when we are discussing laws that are yet to be developed and yet to be established, there are like not present for even more than a decade. So there is definitely a regulatory gap there. Moving ahead with the problem of data localization, a recent law in India came in concerning or addressing data localization, or more like a guideline that came in concerning data localization. So I'd love to have your input, both of your input on the data localization law that came in, and again, like how that comes up with the UAE and how the regulation is there in terms of that.
Okay, so in terms of the recent law which the India has passed in 2023, while it's a very, very important step in the right direction, we also need to realize that the act is still not at par with what GDPR is already providing. Then there is California law for the US, which is again a very classic example, very progressive laws. But somehow India, despite passing it many years after those laws were already enacted, which could have been used as a guiding force for the Indian privacy, data, and passed only last year. The act is not again as fulfilling as it could have been, and I feel that one of the important missing point which I found was that there are fiduciary entities who are responsible to report any breach of data, but somehow the Indian Act lacks any timeline when this breach should be reported. While if you go to GDPR law, it says very specifically that it needs to be reported as early as possible, and a maximum timeline of 72 hours has been put. Now, this is very important in the sense because when we speak about cyberspace, any time that you miss out on, there is a more large, aspect that the evidence may be forever lost. As Dr. Zera had also discussed a bit on the Budapest Convention, this convention again had been initially, had come up only for specifically for these evidences and how to protect them and how to deal with them. And any time that we lose on these things, because anybody who's hacking or trying to uh, put a ransomware to pull out any data for anybody will not wait around for you to sort of search for the evidences that may have been left. And then there are, of course, softwares ransom malwares which easily allow them to hide their steps as well. um, so I feel those aspects are something which India could have, of course, looked into. I am very hopeful that as we've seen that the IT Act was amended a couple of times, there were IT rules which were amended couple of times in order to ensure that we do, change with the changing circumstances and the landscape that we operate in. I'm hoping that again India will do that as well. Now, if we come to the UAE aspect of it, UAE also again in 2022 had a very recent law governing this cyberspace crimes, and you can sort of see it very close to what the IT Act was in India, and it's the Federal Decree 34 of 2021, but came in 2022. Now, one of the good things that I realized which UAE has been doing is, which sort of is, I feel, missing in the Indian perspective of it, is one that a lot of companies who are processing these personal datas, be it big companies like Facebook, Twitter, or small companies like TCS or anybody who take up data for their employees or users, etc. There is no mandatory audit made for them, which basically means that if there is any breach happening, you will not come to know. Or if state entities are actually willing to see whether there is a protocol being followed or not, those things will never come to force. But UAE, on the other hand, though passed this law in 2022, has already included that. And if you are a company based in certain industry, you are mandated to do these audits by third parties so that you can ensure that data breach is not happening. And if at all there is a breach, of course, there are remedial steps that they have to undertake as well. Second important aspect, which I feel a lot of countries, including UAE, have included in these type of their local legislations, are heavy fines for anybody found breaching those. I feel India lacks on that as well. A lot of offenses are still governed by IPC, 354 offenses which are made after 2013 amendment. Voyeurism, cyber stalking, etc. Offenses, and there are not very hefty fines, only offenses who lead to jail time. And then we know how Indian system is, that it takes a lot of time to courts to do the trial, etc. And then a lot of time it doesn't act as a deterrence which it should have. While if we come to the UAE law, federal decree, we realize that a lot of these offenses, be it cybercrime, phishing, defamation, etc., anything to do with the internet, a lot of these fines are very heavy: 250,000 dirhams, 500,000 dirhams, even million dirhams in some cases. And while it may not feel in terms of the amount, but if you see the earning capacity of most of the individuals, it actually would be a very big deterrence to at least 90% of the country in terms of how the income are earned. So I feel those are things which are very progressive in a lot of these countries, UAM being one of them. Of course, India has done that in terms of the first act of 2023. um, but I still feel that uh, hopefully more amendments will allow us to be as progressive as other nations, and we can become an example in itself for other countries to follow as well. um, so that's my overview on this.
Ma'am, please. Ma'am, your mic is not on. Zahra, ma'am, you're not audible.
Audible now?
Yeah.
Yeah. When we talk about legal scenario, let's talk about the countries which actually have such legal picture which sets an example for us. Let's go to US. US has an act called HIPAA 1994 that is specifically for health information of patients. So in India, there is a company called Reventix in Hyderabad, which is a US based company. And recently it merged with Omega Healthcare. So now they are one entity. In the year 2022, in fact, the breach happened that all the information pertaining to patients, it got leaked. And it did not got leaked on its own by the unauthorized use, but somebody hindered the actual transmission process and hence it was stolen. And in return of it, a ransom was demanded. So in order to cover such aspect, US has a very stringent law. It says if you are a hospital or any kind of health institution, you have to keep the data only with the consent of the patients for the period of 90 to 180 days. That's it maximum. If it goes beyond it, you have to take the consent again. And now there are two aspects to it. First is personal health information or personal identifiable data, as well as patient health information. So these two data, they are to be protected for that given duration of 90 to 180 days. So that breach happened, the liability was in USA because it is a US based company. So that is a stringent law that gives power to the companies to power as well as the liability to the companies to pay such hefty compensation in case of breach. Now, when we talk about cyber crimes or harassment, obviously, my co-panelists highlighted the point that Indian Penal Code, it has a lot of provisions pertaining to the punishment as well as the definition of a crime. But when it comes to the enforceability of it, firstly, the very first threat in Indian legislation and judicial aspect is the delay that it has in order to entertain a proceeding and hence to give a potential judgment on top of it. So that becomes the actual threat to the people who are in fact availing the law, but they're not sure when they are going to get the justice. So that is the very first threat. Even we have written thousands and bundles of laws, but the thing is, we are not getting the justice anytime soon, or even if you're getting the justice, it is not up to the mark because simple punishment is there, penalty you have to pay, then you can go out of the jail. And then again, we come across with the concept of habitual offenders. Here, we have reformative aspects, which is a very good thing in criminology, that we try our best to reform the behaviors of the criminals if it is proven that he was medically disabled or somehow there was a reason for his action. So all these laws, on one hand, they are somehow protecting these people. So I will say that yes, it's good, but at least you have to look into the aspect, how much action happened and how much harm caused because of such action. So that is not there in India. Just like we have in US HIPAA, India should also have a separate health protection laws for the patients. We have Information Technology Act, amazing. We have Data Protection Bill 2023, which is again lacking a lot. When we talk about personal data, in section T2 of Data Protection Bill 2023 itself, it gives a definition of the personal data. So let's say, Ayushman, if you have certain data which can be easily identifiable because you have a certain relation to it, we are going to regard this data as your personal data. And how are we going to say that there is a breach? If there is an unauthorized processing of it, if there is a sharing, alteration, destruction of your personal data, which ultimately compromises your confidentiality, your integrity, and accountability, then only we are going to regard it as a breach. These are very technical terms. People like you and I, if any breach happens to us, we are not going to go into the legal aspect. Yes, we are lawyers. We are going to go by the law. But there are people who are teenagers. They don't know what exactly happened to them. Is it actually a breach that happened to them? They don't have to go to section 2, clause U of Data Protection Bill to look after it. So here comes into picture the aspect that there has to be legal literacy about digital platforms like that, about laws like that. We have to include such subjects not as basket optionals in our legal curriculum. We have to propose these subjects as core subjects for legal profession or for any other profession for that matter. So basically, digital literacy is very important. When we talk about UAE, as it is a civil country, we don't have freedom as we have back in India, obviously. And again, there are two sides to it. It's a good thing because obviously government is taking action on each and every aspect. Government is very proactive here. They charge hefty fines even on the minute actions. Now there is a reason because they don't want it to happen again and again. They are not going to give you chances to do it again and then to come back with some kind of excuse behind it. So 2022, the law was passed. The source of this cybercrime and bullying laws in UAE emerges from Article 31 of UAE Constitution, which talks about that there has to be a law in order to combat rumors and cyberbullying. So if the Constitution itself says that, that is a blue book for the country to operate. And I think that is the reason that UAE is very proactive when it comes to that. And UAE is, especially if we go to, if you come to Dubai, you will see that it is a very smart city. And why we call it as a smart city? Because Internet of Things is flourishing here, like in numbers that we can see everywhere. Yeah. So I will give you an example. There was a statement given by Eric Schmidt. He said that in future, Internet will disappear or artificial intelligence will disappear. So when we hear this term, we assume that it will not be there in the future and then only we will be working for it. No, but the implication of that statement is it will be so pervasively existing in every aspect of our life that we will not be able to figure it out where it is and where it is not. So if that is the threat and that is the assumption today, we have to take very stringent action against it. So yes, law in India is lacking a lot. And I believe it's the high time that we take actions, not merely to punish, but also to regulate the behavior. On this line, I want to bring the aspect of blockchain and cryptocurrency. So I believe it happened in the year 2017 that we started talking about this aspect a lot. Then 2018 and it went on and on. So there is a mining process of cryptocurrency. Yeah. Blockchain is simply a platform which gives you the accountability of supply chains, financial transactions. Yeah. Very good, amazing. People got happy that yes, it is introduced, but it is not regulated in India. So how are we going to cover these smart contracts? How are we going to regulate the digital asset that you have, that the owners have or the receivers have? So all of these again are the threat. We are having conferences. I believe in the year 2023, we had 4 to 5 national level conferences on this aspect only, how to regulate the blockchain or the cryptocurrency. But unfortunately, there is no positive repercussion out of it. And there is only that we talk about it, but it's the high time that RBI also takes action. On this line, one more thing. I believe we all are aware with the concept of insider trading. Yeah. So what exactly happens in insider trading? That we reveal the price sensitive information of the company and hence it results into the wrongful gain to one, wrongful loss to other. Now, when we say leakage of price sensitive information, nowhere data protection law talks about this kind of communication. We are only talking about leakage of the price sensitive information or revealing the price sensitive information. In what manner, on what platform we are revealing it, nobody is talking about it because digital communications are not punishable under insider trading regulations, SEBI 1992. That again needs to be amended. Again, when we talk about corporate aspect, Competition Act 2003 is there. It talks about anti-competitive agreements under Section 3. It says if there is an express agreement between the companies or there is an implied agreement between the companies. Nowhere it mentions the fact if any communication happened digitally, whether it will be covered under anti-competitive agreements or not. Again, lacuna is there. So if we as country are in the habit of making a lot of laws, we also have to cover each and every aspect if there is a new variation to technology. Not just making one single law and then say that, yes, it will have an enforcement or it will be the sole law for the regulation or the entertainment. So yes, that's that.
You are absolutely on point with the fact that's something that I totally agree with on as well, is there cannot be a blanket legislation in terms of dealing with something and not leaving things that is up to the interpretation of the reader or the interpretation of the enforcer of the law to have or to process how to proceed with it. One more thing that you mentioned that piqued my interest is how the paper that you quoted, AI will disappear, and that takes me back to a paper by Alan Turing. He's known as the father of modern AI, and he pointed out in his paper Computing Machinery and Intelligence that how and he quoted what is AI. He defined AI as any machine or any software that is able to convince a human that it is a human indeed, and it is not a machine, can be called as artificially intelligent. So it immediately took me back to the same paper that to this paper when you mentioned that AI will disappear, that it will be so persistent that you won't be able to notice if it is there or not. And another point that I would like to mention that Altamish you also brought up is how the differentiation in punishment is here in contrast to US, and that goes back to a very jurisprudential concept of the theory of punishment, like what sort of punishment methods are being applied. And one thing that I noticed, and I believe I'd love to take your views on it as well, is how in India, when we're talking about any sort of digital crime, any sort of crime in the cyberspace, we immediately take it back to, we try to draw a connection of that crime to IPC and not view that crime alone in an independent state. If that crime, if we're talking about harassment or cyberbullying, or to even come back to a more simpler crime or to easier to understand crime, the crime of stalking, we immediately go back to the crime of stalking in the IPC, and we try to process it through that perspective instead of looking at it as an independent crime. So that is also again a lot of interesting points are there that I want to discuss, and we have to again go step by step. So coming back to Altamish sir's point, that is of data localization that he brought up. A thought that I have discussed recently with my seniors here as well as academicians, is what we understood, is to have stringent data protection laws in any country, you first need to have a very solid data localization regulation. If any data protection law without a solid data localization policy is what we call a toothless tiger, is what we were discussing. Now, I would love to take both of your views on this specific thought. What do you feel when you hear something like this?
So I think we can start if I think in the last point that Dr. Zehra had pointed out was how the Data Protection Act defines personal data, but it doesn't differentiate in different types of data. And she pointed out about the medical data very specifically. And then I think this is something which we had missed. I think this was something we should have as a country done it, where we could have defined personal data and then separately defined what's a sensitive data, what could be confidential data, and then we should have had different processes for each type of data, because financial information that a credit card company or a bank may hold may come to be a very confidential type of data. Again, medical data, as Dr. Zara had pointed out, could be a very sensitive data, which can be then used by authorities or even people who are trying to hack and get those data uh, to be used in against the person. And with COVID, I think this became a very huge point. Before that, medical data wasn't really treated as very important or sensitive for anybody. But now with, I think, COVID, a lot of apps came up in different countries, and then uh, people trying to get vaccines, who's getting what, where is he getting, has somebody gotten or refused to have it. These are very sensitive points. And then a lot of time we see, if somebody is visiting a hospital again and again, a hospital may maintain its records, how long they should maintain, whether somebody is allowed to access it, whether just doctors, whether nurses, whether other staff, what protection levels they are doing. So those are, I think, very important aspects of it, which I feel are not really given the thought they should have. Because as we grow as a country, India is growing not just in population and numbers, it's also growing in the number of people who have access to digital phones. Data is one of, I think, the cheapest around the world. So this access to data is of course there with everybody, and people are without realizing the issues that can arise later, are posting videos, photos, etc., on social media, which are easily tracked, saved, and then misused by people. So unless we first deal with these aspects of it, as you pointed out, it'll be a toothless tiger for us to be able to cover all those aspects in a comprehensive legislation. I also feel, as Dr. Zahra had pointed out, we may need different regulatory mechanisms, maybe different agencies, maybe different rules guiding each and every aspect of it. And rather than just one, as you've just also pointed out, rather than just one comprehensive blanket legislation may not be enough. And it's not that there are not classic examples around the world. There are, countries who are doing it. There are international bodies who are trying to come up with different ways of dealing with each of them. And I feel though it's high time that we also look into it. Rather than just one blanket legislation, we should have different processing units. And as a practicing advocate, I've even seen people that who are trying to build their new businesses, who would probably have users. They're shifting their, data centers outside India because they realize that, the protection is lacking. Two, the government has a very heavy arm in terms of taking over or blanket orders against them. We've seen how even company like Twitter has faced such harsh realities, and Madras High Court, did not give them a lot of favor. Then we've seen IT rules being challenged in Bombay High Court very recently, which again had a split judgment. Now again being heard by third judge to have it, something, and then we'll obviously see it finally going to Supreme Court to settle the dispute. Now, what it makes us realize is that, we've lost 2, 3 years. We are just at one high court level, second high court still hearing, Supreme Court yet to have anything on it. Legislative bodies also, of course, are not taking it as seriously as they should have. So a lot of time is lost, and by the time you are able to cover the previous time period, the situations have changed. We've seen AI become more and more generative. We're seeing deep fakes and whatnot morphing, which were never seen even in the last, 12 months also. So by the time we come